Family law clients rarely come to you on their best days. They arrive in extremely high states of distress, navigating the fallout of divorce, custody battles, or domestic abuse. When you sit across from someone who is terrified of losing their children or their home, your natural human instinct is to advocate fiercely and help them by any means necessary. But the rules of legal practice are rigid. Within those rules, it is rarely an initial mistake that destroys a lawyer's career. Usually, it is the panicked, dishonest attempt to cover up that mistake later. Every family practitioner serves as an officer of the court, balancing a deep duty of care to a vulnerable person against an unshakable obligation to the rule of law. When a lawyer allows their empathy to ignore these ethical boundaries, they often drift into the territory of covering up mistakes or facilitating client misconduct. That shift transforms an advocate into a liability, risking both the client's case and the lawyer's professional license. Let's examine the strict boundaries of practice. First, there is an absolute prohibition on acting for both parties in a relationship separation. Even if a couple claims their split is completely amicable, the inherent conflict of interest bars you from representing both sides. You also have to guard against giving informal advice. Offering your thoughts on a friend's divorce over a drink creates immediate, unforeseen professional liability because that person might reasonably rely on the information you provided. Then there is the strict enforcement of client confidentiality. Consider a recent documented case where a paralegal accidentally placed a client's sensitive family court documents into an unrelated immigration file. That simple clerical error carried immense penal consequences. The breach of privacy originally resulted in a 6-month suspended jail sentence for the paralegal. In family law, confidentiality is a fragile legal wall. Breaching it, even entirely by accident, invites devastating legal consequences for the practitioner. The stakes escalate quickly during financial disclosures in a divorce, particularly when one spouse suspects the other of hiding significant assets. This often leads to a self-help scenario. A client illicitly downloads a spouse's hidden financial records and hands them to you. While your instinct is to use this smoking gun, the Ehrman ruling states you must refuse to read them and return them immediately. The legal reality is that possessing these copied documents constitutes theft and a breach of privacy. If you attempt to use them, you can be charged with contempt of court. You cannot use illegal means to achieve a legal victory. Attempting to do so poisons the case entirely and shifts the criminal liability directly onto you. Another systemic trap involves navigating cases against litigants in person, individuals who are representing themselves without a lawyer. Facing an unrepresented opponent creates an ethical paradox. You are strictly forbidden from taking unfair advantage of their ignorance, but you cannot cross the line into offering them legal advice. You can only provide procedural information. You also carry a duty to protect the public purse when dealing with the legal aid agency. Imagine discovering that your client is actively lying to obtain legal aid, such as intentionally hiding the fact that a new partner with a steady income has moved into their home. In this specific situation, your duty to the taxpayer completely overrides your duty of confidentiality to the client. You are legally forced to report the fraud. A lawyer's ultimate loyalty never belongs to the client's wallet. It belongs to the integrity of the justice system and the preservation of public resources. The family lawyer's role involves protecting the client from the opposing party, but also from their own emotionally driven, self-destructive impulses. The strict regulatory rules we've discussed are not designed to punish practitioners. They are built to guarantee the foundational fairness of the entire family court system. If practitioners abandon their ethics in the name of winning, the structural integrity of the courts collapses. That ultimately abandons the most vulnerable citizens who rely on the law for protection. A lawyer's primary value lies in the unyielding professional integrity required to navigate these rules safely. In the volatile, high-stakes arena of family practice, true legal advocacy is defined precisely by the ethical boundaries you refuse to cross.